All right. Good morning, everyone. Thanks for your patience. We're starting a little bit late on this Monday morning. I've got a civil default and status calendar. There were 5 positions. One of them may have gone away, but it's number 5, so we'll get to it when we get to it. The focus here is to get closure where we can on these default cases. I know a few of them, we already have proposed orders, and so you'll just be shoring up the parts that weren't liquidated in whatever the claims are. And I think there were a couple questions with some of the others, but going in numerical order, the first case is Carly versus the Gavinses. Is there anyone on the call for that case?
Yes, Your Honor. Paul Andrew for the plaintiff.
Good morning, Mr. Andrew. How are you?
I am better than I deserve, Judge. I just, the audio is low and I'm struggling with my technology, so apologies if I don't pick up everything audio-wise.
Okay, well, we can hear you just fine. I'll be sure to speak loudly and distinctly. Your client has sued his former client, Mr. Gavins, for legal fees, and then he alleges, your client, that Mr. Gavins engaged in a little bit of a fraudulent conveyance with, I'm assuming it's his wife, I guess it could be his sister, Darlene Gavins.
Actually, his mother.
His mother, oh, dragging mom into this, even worse. And so I'm interested in hearing all the things you need to share in terms of damages. And then we also need to work through what you were able to learn about the Gavinses' military status.
Yes, we did submit an affidavit, Your Honor.
Okay.
I copied Ms. Niles on it this morning. We filed it Friday.
Okay, great. I got my list of questions to bug the lawyers about before late Friday. So when the list was compiled, we didn't have the affidavit yet, but if it's in there, it's in there.
Okay. So that's the military affidavit, Your Honor. And obviously, as you just recounted, my client is an attorney, did have a written agreement. Ms. Niles has that written agreement. I don't know how much you want us to go through, Your Honor. The principal amount was $28,106.78 that was not paid. We then added attorney's fees. It's a contingent fee case, Your Honor. We added attorney's fees to that, expenses of litigation, and the proposed order is there in the, I think Ms. Niles has the proposed order with her.
Okay.
For $50,000, a total of $50,637.18.
And you think you get there through all evidence that's in the record, or do you need to get Mr. Carly under oath to provide some evidentiary basis for any of those figures?
Yes, we'll go ahead and put him on the stand, Your Honor, if you want. He's online.
Okay. I'll get Deputy Gordon to swear him in.
Raise your right hand.
Raise your right hand.
Do you swear affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Good lawyer in hand. Can you state and spell your name for the record?
My name is Stephen Carly.
Mr. Carly, you're a licensed attorney here in Georgia?
Correct.
And in 2018, did you enter into a written agreement with Brandon Gavins for payment of attorney's fees?
Yes, I did. There was a contingent fee agreement.
And he defaulted on paying the amount due to you?
Yes.
And you obviously recorded, did you procure some real property for him as part of a probate proceeding?
Yes, I procured a real estate residence.
And then you actually, in 2020, when you procured that residence, you recorded an affidavit for interest in that real estate and a claim of attorney's fee lien. Is that correct?
Yes,
Okay. And is the amount that he owes you principal, 28,106.78?
yes,
And the amount of interest to date is 9,537.35?
yes.
Okay.
Let me see
And-
those. The contingent fee agreement, I'm sorry, was 2018, and the affidavit of interest in real estate was 2020.
Gotcha.
Filed and recorded.
And then we have the litigation expenses that we've incurred in the in the amount that you testified to or that is in the proposed final judgment
Correct.
of $12,557.56. That's my attorney's fees and publication fees, et cetera. Is that correct?
Correct.
And then court costs were $435.49, correct?
Yes.
Unless the court has some further questions.
I do, but they may be more for you, Mr. Andrew. You did file an affidavit confirming that Mr. Gavins is not active military status. And it may be that the structure of, I don't have your proposed order in front of me. I'm sure you sent it, but I don't have it. Is it a judgment solely against Brandon Gavins? Because if it's also against Darlene Gavins, we don't, I suspect that she's not active military duty if she's mom in this equation, but one never knows. And it also, your claims on behalf of Mr. Carley extended to punitive damages. There was a claim for fraudulent conveyance. But what it sounds like the proposed order is basically a monetary judgment, which is a more streamlined and less complex way to resolve this. And it sounds like your client is very much entitled to it on those very dimensions you described. The amount owed, i.e. the principal, interest accrued, attorney's fees, he's had to pay you to go after this, the cost of litigation, et cetera. I'm comfortable with all those figures. Is that a judgment solely against Brandon Gavins?
A monetary judgment solely against him, yes. The judgment does declare, because the record is clear, that Brandon conveyed a portion of the property, half interest, to his mom after the deed was recorded. So as to her, there's no claim for monetary relief. It's just a declaration that's shown on the record that my client's lien is superior to her receiving her interest.
Got it. Okay, I'm comfortable with that. Mr. Carley, how long ago did you represent Mr. Gavins?
Well, I was originally employed in January 2018, and then we entered into, we worked on the case. There were four caveats to the petition to probate the will, and there was a lot of litigation. We had mediation agreements and a lot of activity, but we finally came to a mediation agreement in June of 2020, Your Honor, and and then I've been working with Mr. Gavins since then, but he just hasn't, he would pay some, but he didn't, he just kept defaulting. And so it just found it ended up in default, and we had to pursue this, Your Honor.
Whose will was being probated?
It was the will of Gracie Ison,
Who is that to him?
grandmother, his grandmother.
Okay. All right. Mr. Andrew, anything else?
I don't think so, Your Honor.
All right. Then I think we're good to go. Good luck collecting, Mr. Carley, but I will take a look at the proposed order and assuming it's all ship-shape, sign it and we'll get it out the door today or tomorrow.
Thank you, Judge.
All right. You two are free to go.
Thank you.
Next up is Community Association of Valley Lakes versus Minnie Barber. We were going to handle this a couple months ago or last month. Maybe it was going to resolve. It doesn't sound like it did. Do we have anyone on for Community Association of Valley Lakes?
Yes, good morning, Your Honor. Danielle Burnett on behalf of the plaintiff.
Hey there, how are you?
I'm doing well. How are you?
Same as you. So what's the latest with Ms. Barber's situation?
We were not able to come to an agreement. I am filling in for the attorney who's the lead on this case, and it appears that she did try to make contact with Ms. Barber or her representative, and they weren't able to work anything out. So we're prepared to go forward today for default.
Okay, let's do it.
We filed our complaint on March 27th, 2025, seeking past due homeowners association assessments, late fees, interest, attorney's fees, and also injunctive relief. The defendant was served on March 31st of 2025, and the affidavit of service was filed on April 9th. To date, the defendant has not filed any answer or other responsive pleading. She's not filed a motion to open default. So we filed our motion for default judgment on June 24th. The damages are liquidated, and I have submitted a proposed order to your staff attorney. The amounts that we are seeking are as follows: $1,500 in assessments, $33,575 in fines, $606.75 in interest, $3,598.57 in attorney's fees. There are also some post-judgment attorney's fees from a previous lawsuit in the amount of $1,420.05. And then I'm also seeking another $250 for my time here today, for a total of $40,950.37. I am here to present evidence of my attorney's fees if Your Honor would like to hear more about that.
I would in just a second. This is all over a mailbox, or there are also some homeowners association fees she hasn't been paying?
Yes, that is correct. She does have issues on her property, but she's also delinquent on paying her assessments as well.
Okay, but the main focus is this mailbox. I mean, I'm assuming, is that what the fines are? Usually you don't get fined. The assessment and late fees, actually relatively small number. And then there's this $33,000 in fines. And is that all related to the mailbox? And it's just the number of days or months that the mailbox hasn't been addressed, or what's behind the fine figure?
The mailbox needs to be maintained. There's a tree that needs to be pruned. There's some bare patches in the yard where there needs to be sod placed. The driveway needs to be pressure washed. And there are also some rocks and other landscaping issues that need to be fixed.
The proposed order that includes injunctive relief for your client and the community there specifies the mailbox, and then it simply says cure any further violations of the declaration. It doesn't go into anything about a tree or bare patches. Do you worry that this injunction won't be specific enough, or what's your thought about that?
Well, it has this catch-all language to cease any further violations of the declaration, which would encompass the landscaping and other maintenance issues.
Okay, if you think that's going to be clear enough, or that it's clear enough to Ms. Barber or her representative that these other matters that you mentioned are included in that, then we can go with that. Why don't you talk to me about attorney's fees?
I was admitted to practice under the laws of state of Georgia in 2017, and I've been practicing since that time. I'm affiliated with the law firm of Pankey and Horlock, and we practice primarily in the area of community association work. My rate is $250 an hour. I work under the supervision of two senior attorneys whose rates are $300 an hour, and the paralegals bill at $125 an hour. These rates are customary for the Atlanta area. We've spent 13 hours working on this matter, which includes drafting the demand letter, filing the liens, drafting and filing the complaint, serving the defendant, attempts to negotiate with the defendant, communications with the client, drafting and filing this default motion, and appearing for court today, and then the administrative and court costs that are associated with litigation. All of these expenses were necessary for the prosecution of this case.
All right. And then it looks like Ms. Vessels filed an affidavit that details the basis for, $25 a day for months and months and months. I guess that adds up. That's the basis for the fines and assessment and late fees lines.
Yes, that is correct.
Okay. All right. Anything else, Ms. Burnett, on behalf of the association?
No, nothing further.
Okay. Well, you've got a proposed order. I can work with that and we'll go from there. Thank you.
Thank you very much, Your Honor. Have a great day.
You too. Bye-bye. All right, next up is High Point Road Recreation Association versus Patterson.
Morning, Your Honor. Griffin Bell for the plaintiff.
Hey, Mr. Bell, how are you?
Doing well. How about you?
I'm all right. Ready to go forward with yours. We've got a proposed order.
I have a proposed order. It would entail an updated amount of attorney fees since the motion for default judgment. I take the position these aren't liquidated damages, so I've got a witness, Ms. Phillips here. She's the property manager. Shouldn't take more than 5 minutes to go through our standard spiel if you're inclined.
I am. Let's do it.
And do you want to swear? Do you have the bailiff swear her in?
Yep, it's good for him to move around.
Raise your right hand. Do you swear affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Lower your hand. Can you state and spell your name for the record?
Nicole Phillips, NicolePhillips.
Ms. Phillips, what's your relationship with plaintiff High Point Road Recreation Association?
I am the property manager for the association.
And in your role, are you familiar with the books and records of the association?
Yes, I am.
Are you also familiar with the governing document, the declaration recorded in Fulton County?
Yes.
Pursuant to Article 5, as well as the Georgia Property Owners Association Act, does the association have the authority to levy assessments for common area maintenance costs?
Yes, they do.
And should an owner become delinquent, does the declaration, as well as the Georgia Property Owners Association Act, authorize the association to levy late fees, cost of collection, interest, and recoup reasonable attorney fees actually incurred?
Yes.
And are you also familiar with the individual accounts within High Point?
Yes, I am.
And have you reviewed Ms. Patterson's account in preparation for today?
Yes.
What is the principal to date that is owed on that account?
$1,141.
What is the interest that's owed to date on that account?
$190.02.
We're here today, so the association has employed legal counsel for this matter. What are the court costs incurred to date?
$250.02.
What are the litigation expenses incurred to date?
$363.41.
And the attorney fees incurred to date?
$3,250.50.
Yeah, that's all I've got for Ms. Phillips. I don't know if you have any specific questions for her, if you just want me to go into my attorney fee statement as well.
I am curious, that has got to be the most barren room I've ever seen anyone testify from. Is there like something hanging on the wall anywhere in there, or this is just the appearance chamber? No answer?
You talking to me?
I am talking to you. No,
I'm sorry.
Mr. Bell's got a baseball field and all these little bobbleheads. At your place, I've never seen, it's just these white walls. There's nothing.
I recently moved, so I don't have everything put up yet. Yeah.
Got it. All right. So if we get you in one of these hearings in a month, it's gonna look lived in.
Yes.
All right. Well, congrats on the move. But it just was very like, yeah, it's like it's an interrogation room. I don't.
Hey, we're in front of Judge Barwick tomorrow morning at 10 a.m. We'll see if she has the same thoughts.
Yeah.
No, I need to put some pictures up or something.
Yeah. Quick. All right, no, that's it, from Ms. Phillips. I'm happy to hear from you, Mr. Bell. It sounds like the attorney's fees have nudged a little bit, so we'll need a new proposed order from you.
I have one and I'll get it to Ms. Niles after this hearing. But I
Okay.
state in place that I'm an attorney licensed to practice in the state of Georgia. I have been since 2019. I've been at this firm doing community association work for too much shy of 4 years now. The rates that we charge for a retainer client like High Point are $325 an hour for senior associate like myself, $215 an hour for paralegal work. I'm the only attorney that's touched this file dating back to December of last year. We've done 11.2 hours of legal work that does include preparation and attendance up and through today's hearing. The amounts that I have are the same amounts that were testified to Ms. Phillips. The rates are standard and reasonable, and the amount of work on this account up through a default judgment are standard and reasonable for the Atlanta area. And just would ask the court grant that pursuant to the declaration, as well as the Georgia Property Owners Association authorizing reasonable attorney fees to be incurred and recouped.
Got it. Makes sense. If you would please send that revised order that reflects the additional attorney's fees, we will be good to go.
I will, Your Honor.
All right. Thank you both.
Thank you.
Thank you. Have a great day.
All right, and there's no one else on. So, number 4, we can dismiss for want of prosecution. And, number 5, you said you did find a dismissal, or you think that it's dismissed? Great. All right, so that one's closed. That would explain why they hadn't presented much in the way of evidence. Are the people for the special master hearing jumping on this call?
They are.
Okay.
So if you'll leave this.
Yeah, hold on one sec. Let me. Good morning, Ms. Graham.
Good morning.
I think we're waiting for counsel for the property owner. Have you had any, I know you looped them in your emails.
Yes, I understood he intended to come. He hasn't entered an appearance yet. He and I have been working on the matter for a while, trying to reach a negotiated resolution. And so he was aware that we filed and things of that nature. And so I understood he intended to come via Zoom, sent him that information Friday, and then looped him in on the email string with Miss Niles as well. So if you don't mind waiting until 10 to make sure that he has up until that time, that would be great.
Will do. I'll go back on mute and we'll check back in at 10.
Thank you.
Sure.
Judge McBurney, I see Mr. Creasy's name up on the top. Hi, John.
Good morning.
There he is. Excellent. Good morning, everyone. I am here so that we are all here so that we can talk about getting a special master appointed. And Mr. Creasy, my understanding is you're not formally in the mix yet, but that you are, at least for purposes of today's conversation, the representative for the property owner in this condemnation matter. And to move it forward, we need to get a special master appointed. And per the statute, we have to have a hearing on that, not just, hey, here's a pleading and would you please do it, Judge? So I'm going to turn it over to Ms. Graham first to set the stage, and then I'll certainly hear from you, Mr. Creasy, if there's anything you want to add before I figure out what we're going to do.
Thank you, Judge. As you know, I represent Georgia Power, and we are here just to appoint the special master. My firm has reached out to Bob Wilson, who is at Wilson, Morton and Downs. He has done a bunch of special master work, both in this area, but also in kind of quiet title type disputes as well. He has conflicts and is available during the statutory time period. In addition to having this hearing to appoint, we also have to set the special master hearing between 30 and 60 days from appointment of the special master. And so he is available during that time period appointed. Speaking with Mr. Creasy, I don't know about Mr. Wilson, but I have told him we will work to have the hearing later of the statutory time period as he and I are in the ongoing discussions. And so if the time to appoint Mr. Wilson, me and Mr. Creasy with his office to get time set within the statutory time period, but also works for everyone's schedule, and submit a proposed order to the court in that regard.
What is different about this condemnation? I have plenty of them, and we've never had to appoint a special master, and there haven't been all these funky deadlines. You got to do this hoop and that. What's happening in this one? Is it a condemnation pursuant to a different statute, or it's because it involves natural resource, or what's going on?
Yeah, so Georgia Power has to utilize Title 22 when it condemns property, which is different than GDOT or City, which you're probably used to, which is under a different title. So we have to have a special master hearing, a recommendation from the special master, and then the court's adoption of that before we have the right associated with the easement we're asking for. GDOT, the city and the county, they file a notice of taking under a different section, and they get those rights automatically subject to kind of an appeal, but it stays within the Superior Court process. And so we kind of have the middle ground. We don't have that kind of very quick process, but we do have this special master process to support kind of project timelines, construction need efforts, but also, we just have a higher required showing before we can get the rights.
Got it. Okay. So it's in fact the plaintiff that matters. And you're right. The ones I'm thinking of are all GDOT. And those flow in a particular way. And this one keeps pulling to the side of what I'm used to, but that's because we're dealing with Georgia Power. And for whatever reason, they're different statutory requirements. And you've helped explain why they're. All right. Mr. Creasy, I put you on mute briefly because with you not on mute, we were getting some feedback loop. So you can unmute when you're ready. Do you have any concerns with the basic framework Ms. Graham just described?
Yes, Your Honor. I found out about this hearing. Brooke and I have been having ongoing discussions regarding a consensual easement here. But I did not know about this hearing date until late Friday. I think it was right around 5 o'clock. And I've not been served with notice of this. The client, I just confirmed, I finally was able to connect with him this morning. He's not been served. And I'm not condemnation counsel. I'm their corporate counsel. The client would like to have time to retain condemnation counsel. And, he didn't even know about this hearing till I let him know this morning. So we would just ask for more time to appoint condemnation counsel. I don't know that we oppose this special master suggested by Georgia Power, but for all I know, he's their man. I don't know. So we'd just like some more time to get condemnation counsel and vet the proposed special master.
Okay, it's a fair request, depending on what more time means. Ms. Graham, are you up? What clock is ticking so that I can set a reasonable deadline? First, I think Mr. Creasy's request is reasonable, but I want to make sure if there is a clock running that we are moving consistent with that.
Yes, so I I don't mind the request. I will say there are affidavits of service. I asked Mr. Creasy if he could accept service of the petition, and he told me no. And so we have been, serving his client directly. I sent Mr. Creasy a copy of the petition as a courtesy copy, but there are affidavits of service on the docket. Mr. Creasy and I did speak at the end of last week, and I told him about the hearing then. That was the first time we had spoken since it had been set. That said, I don't mind waiting for additional time as long as it's within the statutory time period. So the petition was served on on September 19th. And 30 days, it's 10 to 30 days that we should have the hearing. That said, Georgia Power can waive that requirement. So October 19th, I have my time and date app up. October 19th is technically the latest date on that 30th. I'm certain that we are comfortable going into the early parts of that next week if we can't get it reset this week. But we would ask that it be set before. Let me pull up a calendar really quick.
All right. I'm trying to find the service. There are summonses. There's nothing in the docket that says anyone's been served. So
I'm looking in my file. And so I will say I did not coordinate that, of course, directly, but I do have affidavits of service.
Oh, here's one. Hold on. Yep. On the 30th, let's see what that has. Your client is Stonewall Tell Development, Mr. Creasy. I understand not your client for condemnations, but you are corporate counsel. Okay. Let's see. Exhibit B. Okay. Yeah. It was filed on September 25th. Some process server served the register agent and Amin Alabhai on Spring Street. And Matt Lovell, general manager, accepted service on this guy's behalf with permission. So it's been in their lap for a minute.
I thought I was the registered agent of that entity.
Well, you know what? I'm not going to get in the middle of that. There is something in the docket saying that Fulton County was served and a couple other parties, to include yours, were served. And that notice of filing was on the 30th. So it was 5 days after they were served. So you and your client need to circle the wagons, and I'll give you a little bit of time, but he can always proceed without counsel. I'm sure that's not what he wants to do. So Ms. Graham, I interrupted you because I was looking in the docket like, wait, I don't see it, but I do see the affidavits of service. So what is our time frame? You were saying October 19th.
Technically, the statutory October 19th is the 30th day. We can waive that, right? The time frames are for the benefit of my client, and we have been working with them. And I know Mr. Creasy is not officially representing them. He didn't accept service, things of that nature. If we could I know the court has a busy schedule, but if we could have it the 20th or the 21st, which is close, falls on Sunday, moves into that next week, that would be ideal. But I'm happy to work with Mr. Creasy, and understand and want to be accommodating.
So I will be in trial the week of the 20th. We'd need to do it. The earliest I could do it would be on the 27th.
That is fine. I've sent an email to my client since we were talking to make sure that I was authorized to relax this date. It is something they protect. And we are good with doing it on the 27th. And that should be 2 weeks. And if we can get my office is happy to send a new Rule NISI, get that out. If you tell me what time works.
11 o'clock on Monday, the 27th. You're making an unhappy face. Don't do that.
He think it'll be done.
Right, that's the motion to enforce settlement? Yeah. I think so, given that one. I mean, they signed a settlement agreement. I think, yes, 11 on the 27th.
Okay, that sounds great. We'll get a proposed rule NISI to Ms. Niles as soon as we get off of this, and then we will see you back in a couple weeks.
Okay, and just so I'm clear, because I'm not trying to push us outside any statutory ranges, the statutory deadline, as you described it, is truly for the benefit of the plaintiff for Georgia Power. And if we hold the hearing outside that 30-day window with plaintiff's consent, then it's not going to require you to refile this condemnation action.
That's absolutely correct. It is for the benefit of Georgia Power to have the quick timelines, and it is something that we can agree to waive under certain circumstances. And here I've been authorized to do it.
Great. Okay. Then we'll look for a proposed rule NISI for that date and time. Mr. Creasy, you're going to want to sort out who the registered agent is for your client, because it may be the wrong person was served and your client wasn't served. But a process server is saying, here's what we did, and has an address and the person he talked to, all that kind of stuff. And then, more importantly, since you are in contact with the human behind this corporate entity, the LLC needs to come alive and obtain or retain condemnation counsel, so that Ms. Graham has someone to engage with. I appreciate very much you serving as a proxy, but not your role. No one expects you to stay in that position. And we ought to get someone in the mix, because this may well be something that is real simple to resolve once you've got the right legal team in place.
Thank you, Your Honor.
You bet. Ms. Graham, anything else?
Nothing else. We'll have that to you, to your offices this afternoon, and we'll copy Mr. Creasy on the communication.
Great. Mr. Creasy, thank you for your time.
Thank you.
Thank you,
All
John.
right. See you guys. Bye-bye.